EC group, and welcome to our first virtual meeting and for the organization and the last meeting of this year. So I assume everybody's eaten, like done eating, like at the meeting, so we can proceed. Today it's about COVID-19 related issues when it comes to insurance and risk management. And we've got today as speakers is David Patterson, who is a partner with Weston Hurd LLP, and he focuses his practice on construction litigation claims, architectural engineering, product liability, professional liability, environmental law. He's got his BA from Vanderbilt and his JD from Capital University. Then we also have from the insurance side of it, we've got Brian Baumgartner, who is an associate client executive with Oswald Companies in their Cincinnati office. He works in the area of business development, client management, focusing on architects and engineers, commercial contractors, developers, real estate firms, and he consults on and promotes innovative risk management insurance solutions. And what they've done to kick the meeting off is they provided a list of questions for me to ask with cybersecurity and professional liability and then workers' comp and then other issues. Then at the end, if there's any questions, you guys can just chime in. So I guess starting out with the first question, in cybersecurity, with more employees working from home, what are some of the best practices you recommend?
Scott, thank you for thanks for the introduction, and Holly, thanks for having us. I know Dave and I are both excited to be here, and hopefully this will be worth everyone's time. So if you do have questions along the way, please feel free to ask of those of Scott, and Dave and I will do our best to answer. But yeah, along the lines of employees working from home and the best practices that we recommend. It's one of those things that we're seeing obviously with the work at home orders and some of the different government mandates that have come out. A lot of workers are working remotely, so it's something new for a lot of our firms. It's unfortunate, with any opportunity out there, the bad guys and the bad actors are always looking for opportunities to kind of prey and take advantage of the fears and uncertainties that are out there. So many times we experience with our clients that they've outsourced the function as far as they hired an outside IT consulting firm that kind of manages their IT systems and computer systems, but by doing so they haven't actually outsourced the liability. So albeit you might have outsourced the function itself and you're not managing and responsible for the day-to-day operations, you so much to outsource the liability. So something to keep in mind as we go through this. And over the past probably 3 or 4 years, we've just seen an overall increase in cyber-related crime issues, whether it's ransomware attacks, extortion attempts, but it's just been growing out there. So some of the things that we've seen really in the past couple of months since the COVID-19 pandemic has really taken off is these quote unquote bad actors using different types of email ploys that it's an email that appears that it's coming from the CDC, or you've got employees that are working from home and on their computers, and they're just looking for information about the virus. All of these things may look and feel legitimate, but yet it is a ploy for the bad actors to get in. So some of the things that we've gone through and kind of some of our tips and tricks is, if you know that looks suspicious, before you act on it, obviously you can't see people face to face, but you can still pick up the telephone call and give them a call and say, hey, got this email, just wanted to make sure that this was legitimate. Before you act on it, I can't tell you how many times prior to the virus that we have had firms that, you know, they get this request to wire, you know, $1,000 or whatever it is, and they do it, they don't know about it, and you know, the person that was asking to do it wasn't really the person that they thought it was. So using that old adage of, you know, picking up the phone and having that conversation can always help. Making sure that that your employees are using secure networks. Granted, probably not a lot of them are able to work on public networks right now because of the, you know, the restaurants and coffee shops are being closed, but still just making sure that they're using secure networks while working at home. Overall, software. One of the other things that we see that sometimes I think people kind of forget about, but the importance of changing your passwords for your home network. Many times it's set by whatever the internet provider gave you off the get-go. I will fully admit I was one of those that never even thought about that. I thought the one that they gave us was pretty slick. It was something I would have never come up with. But many times we've seen where if you don't go through and change those, that is a way for the quote unquote bad guys to get in. So the other thing that two other quick points is making sure that you've got kind of that dual authentication system. So there's, you know, either a 2 or 3 part verification system to get in. And finally, just taking the time to train your employees and making sure that they're well versed in spotting some of these bad actors that are out there. You know, I think a few years ago, we would all admit that some of the emails that you received was pretty obvious that it was an attempt from a spam perspective, whether it was the language that they were wording or their, you know, grammar, but it was, you know, it was pretty obvious. But I've seen some in the past couple of years that I will admit I probably would have fallen for them too. So I think the criminals are getting much more sophisticated, and just trying to make sure that everyone is aware of that, especially now that you've got a remote workforce, just to make sure that you're keeping your eyes and ears open to those issues. Any questions on that? Or
I was going to chime in too. We're monitoring the group chat too. So if anybody has any questions, they can, you know, type into the group chat. We get them that way. Okay. Question number 2. What is the state of the current cybersecurity market?
So the current cyber market, it's interesting. It's from an insurance perspective, it's a coverage part that has probably been out in the market. I'm going to say probably 15 to 20 years now, which is, it's hard to believe, but it's been out there. We're starting to see a growing number of carriers that are including endorsements on your commercial package policy, so your general liability policy. Which is great, wonderful that they're including that kind of that broader coverage grant. But in reality, it's really not the coverage that you need. So what we're suggesting of our clients is to really consider purchasing a full-blown cyber policy if you don't currently have one. The market overall from a price and coverage standpoint is still relatively competitive. I will say in the past couple of years, we have seen a little bit of an increase as far as rates are concerned, which only makes sense, and it was just a matter of time because the underwriters, for so many years, I personally felt that they were writing the coverage relatively inexpensive for the risk that was out. These risks aren't, you know, it's just not the large, Fortune 500, the Home Depots that are getting hit. It's happening to small firms just as much as it's happening to larger firms. So it's one of those things that if you're not currently buying a dedicated cyber insurance policy, would certainly recommend that you look into it. And for the most part, it's still relatively affordable in the marketplace for the coverage that you're getting. And if anyone's got any questions offline, happy to dig into the real specifics of it, but didn't want to waste anyone's time with the.
Okay. Many times firms are signing contracts that have confidentiality agreements or separate NDAs? How does cyber insurance address those risks?
Yeah, thanks, Scott. This is one of my if I go down a dying man, this is the one thing that I hope firms would learn from us is many times I think folks kind of have this false security that your professional liability policy would provide coverage in the event that there's some kind of a breach of a confidentiality agreement. In all likelihood, that's usually not the case. So we're seeing more and more contracts when we review them that obviously have confidentiality agreements that are either baked into the agreement, so it's almost boilerplate language. And we've also seen sometimes where you're signing separate NDAs for some of these kind of highly confidential projects. And oftentimes, I think there's, like I said, this false security, it's boilerplate language. We don't really take the time to review them and read through them. And one of the things that I was going through and preparing for this, and I pulled up one of our agreements that we looked at not too long ago. And just quickly, I'll read it, but it says that the engineer agrees that disclosure of the owner's confidential information by the engineer may cause irreparable damage to the owner, and the owner will have the right to seek equitable and injunctive relief to recover the amount of damages incurred with the connection of that unauthorized use. Many times these provisions are very onerous, very one-sided, and like I said, I think folks just don't take the time to realize. So, but when you think about it, like I said, the professional liability policy is really intended to cover claims that come from a negligence, an error, or an omission of providing professional services and providing design services. In the event that you had an employee that posted something on LinkedIn about a project that was highly confidential, that information gets out and it causes your client's competitors to gain some type of a competitive advantage. In all likelihood, they're going to sue for your failure to adhere to that confidentiality clause. And like I said, in our experience, most likely the professional policy would not apply, but the cyber policy, which should really be called a privacy policy, would apply. So just another reason why we think it's important for firms to consider that the cyber policy. Not only are you gaining the cyber crime coverages and all of that we see out there, but there's also a coverage grant with respect to these confidentiality and NDA agreements as well. So any questions on that? Happy to take them. If not, I think we were going to jump on to the professional liability side of the house as well. So.
Okay. What is the standard of care in emergency situation?
Scott, this is Dave. I'm going to go ahead and jump in, and then I'll let Brian chime in when he can. So, standard of care in an emergency situation. Well, to begin with, if you look at any of the form documents, whether it's AIA, EJ, CDC, consensus documents, there's no provision for any type of emergency situation. Matter of fact, those documents don't even contain a force majeure clause in the form documents, and we'll talk about force majeure here in a minute. From a standpoint of the standard of care, though, there's a couple of scenarios that I was thinking of that would pertain to the present situation. Either you have signed a contract before or you've signed a contract during the pandemic. So if we look at the first scenario where you signed a contract before the pandemic, the standard of care that you've signed is a typical provision in your contract that you'll exercise the care and skill of an architect or engineer practicing in that locality under the same or similar circumstances. So essentially your contract is binding you to the same or similar circumstances as far as your performance as to the norm. So if in the design phase, the pandemic has not hit, and you're looking at the design, did it meet the standard of care? Well, you're going to be held to the standard of care for the normal architecture and in that under those circumstances because the pandemic hasn't hit. But what about if the CA portion is during, so you've designed before the pandemic, but your CA is after the pandemic hits? So what's the standard of care as to the CA? Well, again, you're going to look at what were the circumstances, and obviously during a pandemic, which we've had, with the stay-at-home order, there is a far different scenario than you would have under normal circumstances, and the ability to visit a site, the ability to take submittals and send them to your consultants. Perhaps your consultants are shut down or have lost some key people to the COVID. Under those scenarios, you have a much different circumstance. Is your standard of care, and the argument would be made that the standard of care for that CA service is going to be what everybody else was experiencing, and that is a far different scenario than under normal circumstances. So when I think about this, I think about the fact that that's all well and fine, but what happens when a claim occurs maybe 4 or 5 years down the road? Because the statute of limitation for breach of contract for violation of your standard of care is 8 years. So 5 years down the road after the pandemic, somebody's looking at how your performance was during the CA, and you're going to have to capture what the circumstances were, and it's going to be your burden to show that those circumstances were different than the norm. And how do you do years later? It's going to be very, very difficult. So from the standpoint of the scenario that I just painted, where you do your design during pre-pandemic, but your CA after the pandemic occurs, then it would be, if in fact you can do it during the CA portion, you go to and you submit an amendment to the contract as far as the CA standard of care to the CA. And that amendment would reference the fact that there's an emergency condition that is happening, and that has affected your ability as a designer to perform your services in a normal, and that the parties both understand this, and that the parties both understand that it's not going to be the normal standard of care, that it is an emergency situation, that the normal standard of care would not be what would be the benchmark designer during the CA. So that would be the suggestion in regard to how you would approach it if in fact you have a contract that you sign pre-pandemic, and you really have kind of two different scenarios as to your standard of care, your normal standard of care during design, but then if you're able to amend the contract, be a different standard of care as far as performance during the construction. Now, the other side of it is, what if you have a contract now that you're executing during the pandemic? Well, the suggestion would be right up front, you address the standard of care as being under emergency circumstances, use the normal standard of care, because you don't want to have to fight that battle 5 years down the road. And I'm looking at the AXA XL emergency services provision that they have on their website, and it talks about, and I'll read this to you because it's a pretty good standard of care for situation where you're signing a contract after the pandemic and you're doing both design work and you're doing CA work. And the AXA recommendation states the following: the client understands that emergency conditions exist. The client further recognizes that time and circumstances do not permit the consultant to perform his or her services with a degree of skill and care normally provided under non-emergency circumstances. The client desires, however, to have the consultant use reasonable efforts to perform his or her services conditions. Now, that AXA XL goes on to also reference the fact that you should, on circumstances, try to obtain a limitation of liability, also get a waiver of damages that arise solely as a result of the emergency circumstances or the fact that the pandemic is affecting the ability of the designer to perform under normal circumstances. So those are the scenarios that I see that would affect designers and their standard of care. But I will say that a couple of other provisions that if in fact a pandemic has really affected your ability to perform, you've signed a contract before pandemic comes in, and because you've had some key spec writer is out with COVID, or maybe your key consultants aren't able to provide their services. There are defenses to contracts in regard to impossibility of performance or frustration of purpose for a contract. Both of those really depend on the lack of foreseeability of the event. So you can defend a contract if you're in a contract for design services, you're not able to perform because the fact you've lost key personnel, or the fact that you've lost key consultants. You know you're not going to be able to perform. You know you're not going to be able to perform timely. You know you're not going to be able to perform to the normal standard of care. Then there are defenses to that, and obviously the importance of those defenses is to put your owner on notice of the fact that you have an emergency situation and you're not going to be able to perform the services at this point in time because of the COVID and the impact to your design team. So we'll talk about force majeure here in a minute, but those are the key points that I wanted to make as far as, and Brian, I'll let you chime in.
No, Dave, I think you hit it. I think you hit the nail right on the head, to be completely honest with you. We, as you were talking, I was just thinking we had a client, it was probably a little over a month now, right when the pandemic was ramping up, and they were asked to design one of these temporary hospital facilities for, with the idea that there was going to be this spike, and if the spike was going to come, and this temporary facility needed to be designed and built, and I believe it was I think the timetable was 3 weeks, and given that compressed time schedule, it just has to be recognized that you owe the same normal degree of skill and that you would under normal circumstances. So, as Dave pointed out, that AXA XL, which is one of the leading writers of professional liability insurance, they've got an emergency services agreement that we happy to share with anybody on the line that would like to look through it. But the idea is just to give you some kind of something that you can push back on and say, hey, given the compressed time schedule, we need to understand these things. So, but yes, that's it for us.
Okay, next question. With the possibility of a remote working environment continuing, how does that affect site observations?
Well, that's a good question, and I'd love to hear what people are doing, but when Brian and I were talking about this a couple days ago, I was curious as to what's going on out there, but I'm assuming that there's going to have to be some kind of meeting of the minds as far as how those site visits are going to be performed, and so discussions with the owner as to how those are going to be accomplished. Again, you might want to amend the contract as to how those sites are going to be performed so that the contract reflects that. But I can see where either somebody is going to be walking through the site with a camera, perhaps somebody that is owner's rep, maybe even one of the contractors walking through the site that's on site, so as to keep as many people away from the site as possible while construction continues. And then that representation is sent to the design team for their review. Now, remember that typically the contracts for site visits say that you're looking for general conformance. You're not looking for continuous and exhaustive. So can a camera suffice? Yeah, maybe. Is it the best thing you can go to the site like it's typically done, to spend time at the site and see the condition, see as to whether or not there's general conformance That's the other possibility, is maybe using a drone, staying off-site. I don't know how many designers have guys that are efficient using drones, but there are third parties that could be brought in to use a drone to circle the site, look at specific areas, maybe even that guided by the design team as far as how they want the drone to focus on. So I think those are possibilities. But again, I think because of the nature of the contract, if it has a typical language, there's protection in the fact that you're looking for general conformance. I think both of these methods would be satisfactory. If the contract requires site visits weekly, that may have to be modified to maybe monthly. But all of those things need to be considered, and they need to be discussed with the owner so that there's some expectation between both parties as to how those site visits are going to be conducted. Brian, you have any thoughts on that?
No, I agree. On this one was just, if you are going to do a quote unquote unconventional site observation, documented, and to your point, Dave, that you and the owner or client have discussed it, and you explained that, this remote observation, may impact what we're able to accomplish in-person observation, and making sure that both parties are on the same page. I think more times than not, Dave, you can speak to this too, but when we see claims coming in, it's because of that expectation gap, and one party thought one thing, the other party thought the other thing, in that middle ground.
Right.
It's more times than not where we see the issues arise.
Thank you. Next question. What is force majeure and how does it apply in contracts?
Well, Scott, as for the form documents don't address it, but typically clients that I work with, I have, when they have terms and conditions, I include a force majeure. Force majeure clauses are long-standing. They typically related to acts of God, tornadoes, hurricanes, things of that nature that impacted a project or impacted whatever was the scope of a contract, whether it's construction or something else. It allows for the parties to essentially put the project in stay so that there is no impact financially on a liability basis to the parties until the act of God has been resolved and you can start to get the project back to the condition it was before the act of God. Force majeure clauses have been in the sense that they now cover a multitude of things that would impact a project. But I will do them, and if you have them, it's a good thing. But you also need to understand that they're limit the use of force majeure. They're very circumspect in regard to what is contained in that force majeure, highly favored. So the burden will be on the party that is affirmatively using the force majeure clause to be able to say that the condition that impacted the project fell within the terms of that clause. So the first force majeure clauses typically now will include things such as, government interference, such as pandemics, a multitude of things. And the more specific that they can be, the better off from the standpoint if is the pandemic that affected your ability to perform. And it specifically says in that force majeure clause that a pandemic is one of the considerations for implementation of the force majeure, and that government orders subsequent to those pandemics that affect the ability of the parties to perform. Those are the types of things the courts will be looking at to actually enforce the force majeure. But the burden is on the party that's seeking affirmative release from the force majeure to show that, in fact, it was in the contemplation of the parties at the time they signed the contract. So recommend you have them if you can, but at the same time, they better be written carefully in regard to covering as many things specifically as possible.
Next question. Should thought be given to physicians as it relates to COVID-19?
You know, that's an interesting question. Future design implications as it relates to COVID-19. You know, I would say that from the standpoint of standard of care language, again, be very circumspect as to the care. If you think that there are going to be design implications, making sure that your standard of care references the fact that COVID is impacting the ability of the designer to design, that normal circumstances don't exist, and that COVID could impact from the standpoint of perhaps the design team losing some key personnel or consultants. So again, the standard of care should be carefully scrutinized to make sure that you're correctly reflecting your situation because of the impact that COVID had in regard to the designer's ability to perform under a normal circumstance, different than under a normal circumstance. Brian, do you have some thoughts on what that one is?
Yeah, Dave, my other thought was we've had a couple of clients that have reached out to us, and by clients and firms that have reached out to us and have said, hey, some of our process of redeveloping their workspace for their employees when they come back to the office, and how does that design kind of relate to COVID-19 and just future implications with other respiratory related diseases as well. And our thought was, and I think Dave, you were definitely hitting on it as well, is what we don't want to happen is by somehow increase you as the design firm are somehow touting yourself as, we are experts in COVID related or respiratory related disease, because in the event that you do, you've increased your standard of care, and it could definitely cause issues downstream. So what we had come up with and solutions that we had tried to figure out was, a way to say, hey, we as the consultant, we as the design team, we're going to put our best foot's effort. We will endeavor to provide a workspace that takes into consideration the implication of COVID-19 and other related issues, but by no means are we the experts, and by no means can we be held liable for infection and different things along those lines as a result of our design. So just trying to, like Dave said, carefully word that standard of care wording and making sure that we're not increasing our standard of care to a level that quite honestly we should, because no one is an expert in this. So we're all learning as we go. So anything to add on to that, Dave? Or
No.
Okay, next one. How does the Good Samaritan law impact COVID-19 issues, I guess?
Well, Ohio has a Good Samaritan law. It's revised code 2305.23, but the Good Samaritan law only applies in Ohio to medical care. So physicians, even a layperson that renders medical treatment or care to somebody in an emergency situation, is going to be immune from liability. But it doesn't have anything in regard, or it doesn't have any impact in regard to a designer under emergency situations. So Good Samaritan law is not going to apply to our engineer designing during the pandemic. There is an interesting concept, though, and as I started to think about this one, there's the Federal Volunteer Protection Act, which is federal law. And that Federal Volunteer Protection Act says to the effect that if you're a volunteer for a nonprofit, say you're a volunteer for Red Cross, and your field and your profession is as an architect or an engineer, and Red Cross wants you to assist because they know that you have some design background in putting up one of these emergency facilities. And you do so, you're not paid, you're doing so in your capacity as a volunteer for the Red Cross. And perhaps you forget to put in some kind of purlin or something, and there's a collapse and there's some property damage. The Federal Volunteer Protection Act, because you're acting in your capacity as a volunteer for a nonprofit, and you're not engaged getting paid for your services, then potentially, I'm not going to say all situations, but potentially you're covered by the Federal Volunteer Protection Act, assuming that you were volunteering, you had been a volunteer for that agency, and you were functioning solely in your capacity as a volunteer. So there is a little bit of protection, but it's under the Good Samaritan law that we all think of. It's not going to apply to the COVID situation as far as designers are concerned.
Moving on to workman's compensation. How does workers' compensation insurance respond to COVID-19?
Dave, you want me to go or you want to go?
Yeah, why don't you go, and I'll look at my notes here, Brian.
Sure. So generally speaking, workers' compensation, is intended to it's intended the sole remedy to provide coverage and for workplace injury, right? And each state has their own nuances as such, and what is considered, what's covered and what's not covered. But just generally speaking, kind of high level, historically speaking, viruses, colds, and those lines have usually not been work comp related issues because it's just so difficult to track exactly where you came in contact with the virus or the cold or the flu, and how do you prove that you came by it at the workplace. It's pretty clear and cut. If you're performing site observation, you're on site in the head. That's pretty obvious, right? That was the causation that caused the issue. But with viruses and colds and flus and what have you, it's very difficult to prove that the workplace is where I came in contact with it. And Dave and I looked at the Ohio, the BWC, the Ohio Bureau for Workers' Compensation, and there was three things that I really took out of it was, generally for these occupational diseases to be covered, the claimant. So it puts the burden back on the claimant, back on the employee. First, that it was contacted during the course of employment, that it was particular to that employment. So I always use the example of if you had someone that was performing data entry and data processing, right? They're spending 8 hours a day keying in information that's particular directly to the employment, and that that they created a greater risk than of contracting the disease than what would have normally been found in the public. So that's kind of the three-party test that they usually use. And the issue that we see is it's not so much from the state perspective that we're concerned, but throughout the country, there is a growing number of laws and bills that are out there. California was actually the first that passed a bill that takes the burden from the employee to prove that the injury happened at the workplace, and it puts it on the employer to prove that they didn't contract COVID at the workplace, and it's very difficult for the employer to prove that. So it's kind of looking out at some of these presumptions of coverage that are out there in the different states that could have an effect here in Ohio. I know there is a bill, I believe, in the Ohio House right now that is geared more towards first responders, emergency workers, and things of the such, which does make sense. But there's also a precedent that potentially could cause issues down the line. So anything to add to that, Dave?
Workers' comp from the standpoint of diseases, occupational diseases, they typically are looking at dust, fumes, gases, toxic chemicals, infections, radiation, and trying to determine as to whether or not those were caused on the job. Typically, those are the ones that the BWC sees and that are from the standpoint that they are received and the worker receives benefits. It's in those areas. But like you pointed out, flus and something like this pandemic, COVID, is a bit of an unusual animal. And the employee is still going to have to show that they contracted the COVID in the course and scope of their employment, as opposed to being out in the general public and contracting it. So it's a pretty tough burden for an employee, and unless you go to the state of California has, which puts the burden on the employer, and many states may go on that direct. Yet so far in Ohio, the burden's still on the employee to show that they got it in the course and scope of their employment. As a matter of fact, I'm looking at revised code 4123.01. And a disease that is contracted in the course of and arising out of employment is specific and or peculiar to that employment, where the risk of contracting the disease from the employment is greater in degree than from the public in general. So as far as the COVID, is it provable? Sure, it is provable, but there are some pretty heavy burdens on the employee to be able to establish that it's related to their work environment. So I really haven't been tracking any workers' comp, and it's not my field, but we do have attorneys in our office that do track it. Right now, it's still a little bit early from the standpoint of how these claims are being handled by the BWC.
We actually have a question in the chat box, and it says, what if in that scenario the employers are not following the governor's guidelines?
I would say that that would certainly be a strike against the employer. I don't think it automatically is going to produce benefits. I think that the Bureau is still going to go back. Oh, no. The Bureau is still going to go back to whether or not the employee can establish that, in fact, it was related to the employment. And they probably have a little better opportunity to do that based on the fact that they can show that the employer was not following guidelines. So I would think that the employee might have, in that scenario, a much better opportunity to be able to prove that it was contracted in the work environment.
I guess there was another question here too that I got privately. Should our industry expect increased workman's comp and or employers' practice claims due to COVID? And if so, should we consider increasing policy limits?
Brian, I'll let you take a shot at that one.
Sure. I think it's one of those things that that we're going to have to continue to watch and see what comes out of our legislative bodies. Especially with California and enacting the law that they did. It wasn't a law; it was an order by Governor Newsom. If something was like that happened here, most definitely it would raise a concern. The other thing to consider too is workers' comp is a statutory policy, so they're going to pay you so much for an arm or limb, and then the employer's liability, which is always intended to be when coverage that would provide coverage in the event that a party sued outside of workers' comp. Something to consider there is more times than not, the limits are usually set at $1 million of coverage, and the the policy, if you purchase an umbrella, would usually drop down and provide higher limits as well. So something to consider. I think it's one of those things that I think we have to watch and see how the how Bureau reacts and how our how the state reacts as well.
Yeah, I got just one more question. Just a general COVID-19. Are there other risk management and insurance considerations given COVID-19?
So I think, overall, it's definitely an unprecedented time. I think we're all learning as we go, which we've definitely spoken on before. With the return, folks coming back into the office, I think it's an opportunity to make sure that you're reviewing those CDC guidelines and that you're doing everything you can to follow those. The thought that popped in my head from a workers' comp issue is, in the event that an employee did allege that there was, negligence on your all's end, you followed those guidelines, at least you've got some kind of a defense that says, hey, we followed the guidelines that are out there. We're doing everything we can, so you're not just hanging out there dry. The other thing that we've seen, there's been a lot of talk in the industry as well, from a business interruption standpoint, which is a property coverage policy form that is really intended to provide coverage that take a manufacturing facility per se that produces widgets, and they've got a fire in their facility and they're unable to produce widgets for 4 or 5 months or 6 months or however long the time frame is while they're rebuilding. The business interruption policy is intended to pick those damages and that loss of revenue that they incurred during that time while they're rebuilding. And there's been lots of chatter out there in the marketplace as far as, is this COVID-19, is that a business interruption loss? By and large, what we've seen is most of the insurance companies saying no, that they don't consider it to be a covered peril under the business interruption policy, mainly because there hasn't been quote unquote direct physical damage to the premises. If you think back to the manufacturing example with the fire, there was obviously a direct loss to the property. There are also there's also groups out there, and there's been suits that have been filed against the insurance company saying be considered a business interruption loss. So it's one of those things that we're continuously watching. There's been lots of restaurant groups in California and really all over. I know there was a group in Cleveland not too long ago that has filed suit, and it's one of those things we're watching there. I would say a lot of the states right now have bills that are sitting in the state houses that potentially retroactively could go back and require the insurance companies to cover this as a quote unquote business interruption loss, that loss of revenue that folks are seeing. And if that was the case, it would definitely be something that would have to be supported by the federal government. Quite frankly, it would probably bankrupt the insurance industry, and it would take away reserves that they have set to pay out for other claims that they're expected to pay. So once again, it's one of those things that we're watching. And there's also been talks in Congress about setting up a pandemic insurance act that would provide, similar to terrorism and after 9/11, that would provide some coverage on a go-forward basis. Again, one of these things that we're continuously watching and keeping abreast, but hasn't been any movement yet other than there's been some proposed legislation out there.
Hey, Brian, what if there's a presence of bacteria in the premises? Would that constitute some type of property damage that would trigger it?
It could potentially. The other after the SARS pandemic, which was back in I think 2000 mid 2000s, a lot of the insurance companies have come out and further put exclusions on their policy for viruses and bacteria and communicable diseases, which was another attempt, I think, for them to try to draw that line in the sand that they weren't intended to cover. But I will say this: each situation is unique on its own merit, and as the insurance broker, we are the conduit between our clients and the insurance company. Ultimately, it's the insurance company that makes the decision. And if you have experienced loss, or you think that there is the potential for loss to be experienced, I would urge you to call your broker and give them the facts, and then you can make a decision from there on out. But like I said, it's not our role as the broker to determine coverage. We're strictly the conduit between you and the insurance company. I will say what we have done with a lot of our clients is, just given the chatter that's out there in Washington, in the event that this was to be passed, the insurance companies would be asking some pretty specific questions as far as when did the loss occur, what kind of revenue have you lost, and all of those things. So if you are experiencing loss, or you think you will, I would urge it to reach out to your broker and discuss the circumstances of each.
What about civil authority coverage, Brian? Is there, where the government steps in and orders shutdowns, like what happened? Is there coverage for that kind of civil authority orders?
So it's a good question, Dave. The policy states, from the civil authority standpoint, a lot of the policies do have coverage for civil authority. The issue that once again comes into play is that it's got to be a surrounding business that has been affected. Let's say a surrounding business had a fire or suffered damage after a tornado, and the government closes down access to your street. But once again, it's tied back to that direct physical loss. And unfortunately, right now, from what we've been seeing from most if not all of the insurance companies, is that without that direct physical loss and damage to property, even the civil authority wouldn't come into play. But once again, if each case is on its own merit, and I would highly encourage you to reach out to your broker and discuss the specifics of such.
Okay, that was the last of the questions I had. Does anyone else in the group have any questions?
It looks like in the chat box, there's a question. It says, do we have liabilities due to our staff coming back into the office if they happen to catch the virus, whether they get it in the office or elsewhere?
Brian, I'll take a shot. Again, that would probably be a workers' comp issue, since that is the monopoly in Ohio as far as coverage. Their lawsuits can be filed for an intentional tort in the workplace if you can show that in fact the employer was so reckless or actually intended to harm you. Then you can go outside the workers' comp area and file a separate suit against the employer. So you would have liability as an employer if in fact that could be established. But again, that's a pretty high burden and pretty high standard. But otherwise, I believe that would still be covered under a workers' comp claim, and the Bureau of Workers' Compensation can cite, again, this is not my area, but can cite the employers for some, what they call VSSR, for violation of specific safety regulations. So there can be some penalties that are on the employer if they didn't follow some guidelines in regard to protection of the employees. So the employee could recover workers' comp. There could be cited to provide under VSSR claims. And there could be potentially intentional tort claims that could be brought against the employer if the employee can prove a very high standard that the employer intended to injure the employee.
Dave, the only thing I was going to say is, Oswald, we've put together a return to work toolkit and program that's got some procedures and surveys in it and things on those lines. And one of the parts in the guide that we put together is, ultimately, if for some reason the employee doesn't feel comfortable for whatever the circumstances returning to the office, granted it's a slippery slope because now all of a sudden everyone doesn't feel comfortable and everybody wants to stay home and doesn't want to come back. And I think you gotta work with each individual employee and understand, what their fears are and what their concerns are. And then again, following the guidelines that are out there, and you've got some kind of a defense.
Any more questions? We're getting right near the hour mark, so it's what we scheduled for this, but I guess I'd like to thank Dave and like to thank Brian for the meeting, Holly for setting it up. And this is our last meeting till the fall. And Holly also wanted me to remind everyone that ECEC Ohio will be having their annual meeting virtually similar to this year. And it'll be taking place on Thursday, June 11th at 10 a.m. And you can register for it on the ECEC Ohio website. I've got a long link here that I won't read out for you to copy, but go to the website and you can log in there and register.
Scott, I'd also say that if there were questions as a result of comments we've made, maybe I wasn't very clear in any portion, standard of care, whatever, they can simply contact Holly and Holly can get a hold of me and or Brian, and we'll be happy to answer any questions that come up if they think about anything afterward.
Okay. Well, the absence of any more questions or anything, I guess that ends the meeting. Thank you for everybody for coming and speakers, and Holly, thanks a lot.
Thank you.
Thank you all.
Have a good day.
Thanks, guys.
Bye.